the Federal Court Board of Bar Examiners and Education. This afternoon, we're going to be talking about some of the experiences I think we all have shared in virtual proceedings, and specifically related to depositions, arbitrations, and mediations. And so you're probably wondering, now that our masks are off, the economy is open up, who the heck wants to do virtual proceedings anymore? I certainly don't want to. I like being in the courtroom or the deposition room, looking my adversary in the eye, or having my witness next to me and shaking everybody's hands. But so my preference would be to be in person, but I think Bob Duffy and Magistrate Judge Sullivan have different thoughts on that, and may want to prefer in the virtual world doing some of these proceedings. So I did want to introduce our panel. I want to welcome everybody again. Bob Duffy, who's a founding partner of Duffy and Sweeney in Providence, will be speaking about depositions and best practices related to taking and defending depositions in the virtual world that we find ourselves in. Magistrate Judge Patricia Sullivan, everybody knows her. Of course, our favorite mediator, spent quite a bit of time mediating cases from her dining room, and she'll explain why that is. She'll be talking about mediations, and I will be speaking about arbitrations and court proceedings. So without further ado, I'm going to turn this over to Bob Duffy to discuss depositions. Bob?
Thank you, Matt, and welcome everybody to this Lunch and Learn. And I was looking forward to actually talking about this because I'm very much like Matt. I can't wait to get back in person, but the reality is that I don't think that's going to happen anytime in the very, very near future with regard to depositions. Some people find them more convenient without travel and so on. It certainly is an advantage to the defense, and I think as long as there's a choice that has to be made and it has to be unanimous, I think that we're going to continue to see remote depositions. And I hope that ends soon. I really do. But anyway, let me go right into it. I don't have time to cover this topic fully, but I do want to bring out some things that are important that you need to consider. And maybe you all have been conducting these, so this may be a bit redundant. But I've done many remote depositions in complex cases since COVID started, and I just have a few thoughts I'd like to share. I'd like to work off, and I'm not going to put this up yet, but this will be available. We'll put it up on the screen before I'm done. A remote deposition protocol that I negotiated, heavily negotiated with 3 other firms in connection with a hotly contested case on the business calendar of Massachusetts. And then I'm going to work off the application of that in real life and how that has played out, because there are some things I might do differently next time, knowing that what I do know now regarding what can happen and often does in these remote depositions. When we negotiated this protocol, it was in the midst of the COVID, the high point of the COVID pandemic here. So there was really no choice. If you're going to conduct the depositions, they had to be remote unless everyone agreed otherwise. So obviously that's part of any protocol, would be a decision that all depositions shall be remote unless all parties agree, and that parties and witnesses and counsel agree otherwise, whoever would be present. The second issue that I can't wait to change, and I hope it changes soon, even if depositions are remote, is where the court reporter is. Because all of you who've conducted these depositions know that almost every deposition, there's a problem somewhere along the line where the court reporter can't understand the witness, can't hear the witness, has a problem with a connection. I've actually had court reporters, we can't see them waving their hands, and 5 minutes goes by and they didn't get a word of it. and we got to go back. And there was one case I'm aware of where it was an hour and a half when no one noticed that the court reporter was no longer on the screen because they were on there were so many people on the screen. And that whole thing had to be done over again. She had none of that testimony. So I would suggest that now that things are opening up, that perhaps some agreement can be reached that the court reporter, if agreeable to the court reporter and the witness, be present with the witness. I think it's very, very important, if at all possible, that that be done. So I think for those of you who are taking depositions, ask for that. It's not only because the court reporter gets better testimony or more accurate testimony, it's because the court reporter is your eyes and ears in the room. I can tell you that, and I'm going to get to some of these things soon, but as much as we trust all members of the bar, there is just so many opportunities where things can happen that you don't see as the questioning attorney, that raise questions in your mind whether or not something has happened, and it causes a lot of mistrust. I had a case, a deposition recently where the witness was very well prepared. She answered very slowly. She answered very succinctly. She took forever to read a document. You know, she was very well prepared. It was a difficult deposition being remote. But I got to, there was a break taken, and then I got to another question from a document. And she then went on, she picked up her pace, she probably doubled her cadence, and she recited about a 4 or 5 sentence answer. And her face was down. She was looking down. And I as much as I hate to accuse people of anything, I had to ask her, are you reading from a document? And she looks up and says, no. Do you have any documents in front of you? No. And I asked her counsel, will you please confirm, who's very close to her, by the way, at the same table, confirm that there's no document in front of her. And he just goes on a tirade that I would dare accuse him of unethical conduct and this, that, and the other thing. And I finally asked the witness, reminded her that she was under oath. And I said, I want you to tell me right now, you know, and she said, no, I wasn't reading from a document. I could have, there's really nothing I could do. I couldn't prove it. I just knew in my heart of hearts something was happening there. So if you can have a court reporter present in the room, it's really of great value. If you don't have a court reporter in the room and the defending attorney is there, which they should be, if you're defending, always be present with your witness in the room. It's a great support to the witness, both emotionally and otherwise, in terms of communicating with them during breaks and so on. But if there's no court reporter in the room, you really need to ask a bunch of questions. And I would even suggest in some cases, you ask the witness to scan the room with her camera to see who's in the room. But you need to confirm, and this should be in the protocol, no one is present in the room other than the defending attorney. Nobody, for any reason. 2, that she has no applications open on whatever device she's using to Zoom the deposition. 3, that she has no documents in front of her other than marked exhibits. And we'll get to that, why she would have marked exhibits in advance, but no other documents. 4, that she hasn't written, there's no writing on any of the documents that was not on the document when it was received. And to that end, spot check. Ask the witness when you inform the witness to look at a document, an exhibit, to pick it up and show you the document. Just turn it so you can see the exhibit number and make sure that's what she or he is actually looking at. Those are very important, and they need to be done with every deposition, because otherwise any type of thing can happen, and often does. The last thing I ask, and it depends, you know, it depends on whether I know the attorney or not, whether I, you know, have had a long relationship with that person, I really trust them. But if I don't, I will ask the attorney how close the attorney is to the witness. I will ask the attorney if any screen is facing the witness other than the screen the witness is using. I will ask the attorney not to provide any documents to the witness, that the exhibit should be next to the witness and the witness should get the document, him or herself. And if the witness needs help, then the attorney must be visible, hands and body, showing what help that and a head, obviously, showing what help the attorney is giving. I know this sounds very suspicious, but I can tell you that I've had attorneys that have, they have actually shut off their video to help a witness. And it's just, you turn your video on. So you can't be doing that. And it's all because we're not present. These all happen because we're not physically present. That's the only reason any of this can happen or that we have to worry about it. In terms of other media devices, no cell phones. We had a case once where a witness was receiving text messages and her phone, his phone was next to him. And the text messages, at least in one instance, were related to the deposition questioning. Another party in the case was texting a reaction to a question. It wasn't anything like they intended to help the witness. It's just well, that was a ridiculous question. Make sure that we take care of that next time or something. Something like that. But again, other means of communication, not just the computer, need to be shut off and not available. I want to get to exhibits. I know I'm going very quickly, but I'm trying to get as much in as I can, and I'll give time for a few questions as well. Exhibits. Here's the issue with exhibits. If you haven't done many of these, since you're remote, you really have two choices. You can screen share, or you can pre-mark your exhibits and provide them in advance. Now, if you have a complex case, screen sharing is very, very difficult. If you have documents with multiple pages, it's very difficult because only one counsel controls the screen. And if you send digital copies to opposing counsel to screen share with the witness, you don't know what that attorney is actually showing on his screen. That attorney controls the document. So I don't recommend that, okay? If you ask opposing counsel, can you pull up exhibit 25 and show the witness and go to page 3, you're basically telling the opposing counsel, this is my plan and this is what I'm doing, this is how I'm doing it. You got to tell them in advance before the witness sees anything. And then he's doing something with the witness. So I don't recommend that. If you're going to screen share, I recommend you control the screen, the deposing attorney control the screen. Okay, that raises other issues, which is if you don't have help doing this, then you're going to have difficulty because you're going to pull the document up on your screen. Now everyone's blocked out. So you're going to minimize your document. Now you're going to have trouble reading it because you want to be able to see the witness and whoever else, the deposing, defending counsel and so on. So I'd recommend you have another computer and a paralegal or someone with you on another device who's zoomed in as well, who can control the screen sharing. But I don't recommend screen sharing. It's proved very difficult, and you have to do it almost in every deposition if it's, you forget a document or you have to cross-examine on something you didn't anticipate. But I wouldn't recommend it as a general rule. Here's the problem with pre-marking exhibits. If you're like me, I might show up with 40 exhibits right there, and I might use 20 of them, all right, at a deposition. I never use all the exhibits I mark. I don't know what the witness is going to say.
Because Bob likes to throw everybody off. That's all. It's
yeah,
just,
I do.
it's just
I bring in
employees.
piles of documents just to intimidate them.
That's right.
So now you have to pre-mark everything, and opposing counsel wants it the day before because they're not going to want their witness reading it on the screen. So they're going to want to print it out. So you have to be ready the day before, which I seldom am ready. It's sufficient time to get all my exhibits out the day before. And so it's a real fire drill every time. And you invariably forget a couple, and there's always a squawking about it. Well, these are too late. You can't use them. Of course I can use them. But so you have to be ready to get them out. And then now you've shown opposing counsel all the documents you thought you might have used. So they're marginally relevant, and they may be very relevant if the questioning goes a certain direction. And you've given those all to opposing counsel in advance. And you do that for every deposition. But there's really no way around it that works in anything other than a simple case. In a simple case, screen sharing is not a problem. If you've got 10 exhibits and they're not a lot of pages, yeah, I mean, that's really not a big issue. But if I'm opposing counsel and I'm defending, I'm going to ask you to send me those anyway, so I have them, in advance. In terms of the mechanics themselves, the notice of deposition, make sure you understand the local rule and make sure you understand the state rule. For example, Massachusetts, if you practice there, has Rule 30A, which we don't have in federal court here. And 30A requires, it's a deposition by audio-visual means. And you have to meet certain requirements in Massachusetts and give particular notice under 30A that you're noticing an audio-visual deposition. You don't have to do that for Zoom. Okay, so you have to know the distinction between whether you want to record the deposition using audio-visual means or whether the deposition will be recorded by the court reporter as part of the Zoom. So in one context, you don't need a specific notice. In another, you do. The other thing is you want to say at the beginning of the deposition that you understand that this may be recorded by the court reporter, but it is not to be used as a recording. It cannot be used as an official recording of the deposition. So someone doesn't try to get the video if it's saved. Typically, court reporters, I can't say typically, not all of them record it other than audio, but some record the video as well so they can go back and check. And so you should ask whether they are or they aren't and make sure that you say, if this is your view, that this, if it is being recorded, it's not an audio video recording and it cannot be used for any purpose in the litigation, the recording itself. Also know the state and federal emergency orders, nationwide emergency orders, which were put in place to form the basis of proceeding in this way, because there are any number of state laws that are not complied with. For example, a remote notarization, absent those rules and the law in the particular state. So those are just some things that I want to mention. I think I'm getting close to my time, but I would like Nora, if you could please pull up the draft stipulation, and this is available if anyone wants a copy of it. It's just a draft, generic stipulation, which I put together, and I, in a particular case, but I've had different ones in different cases. So very quickly, yeah, right there is good, Nora. This is a form where you just go through each of the categories of issues that you might or will likely encounter. And just slowly, if you can scroll down the first page, Nora, so right there is good. So you've got the decision that all depositions shall be remote unless everyone agrees otherwise. All right. Given where we are in the pandemic, and it seems to be the reopening, it may be you want to change this, that one, maybe maybe the witness gets to decide, or I don't know, you may want to review that. The next one is the court reporter one. Again, I would change that, in future depositions, because I want my court reporter there. The next one, defending attorney may be present, and if you're defending, I highly recommend you be present. I can't say that enough. It's very important to the witness and to the support for the witness, just as you would in any deposition. The next one deals with defending attorneys who go rogue on you. You know, they disappear, they bend over, and all of a sudden they're gone for 5 minutes. You don't know what happened to them. They're under the table. Who knows? I've had this happen. So it's it's basically, well, wait a minute, where did you go? Are you there? Can you come back, please? You know, but it's kind of humorous in a way. The no one should be present in the room again goes to, take a look if you have to. Scan the room, ask them to scan the room. It's embarrassing, but do it. Go ahead, Nora, you can go down to put 5 at the top. Yeah. This just has to do with all the media devices we talked about. The next has to do with the documents in front of them. The next has to do with exhibit exchange, which we talked about. If you could go down, Nora. In this particular case, B here, you can see that we allowed deposing attorneys to screen share, but we mandated that they still provide digital copies. Because this particular case, there are so many exhibits because you don't know what you're going to use. And we've had depositions where 100 exhibits were pre-marked. That it gives the defending attorney time to preload them, have them available, have them in order on their, on their computer. And also, defending attorney, it is a great benefit to be able to scan through them quickly and call you witness the night before if you have time, or bring them in to go over some of them. So that's it. The only other thing I want to mention is the 7-hour rule in federal court. This is really, really important. I have not had a deposition that I haven't lost at least a half an hour because of technical difficulties. And they could be the witness can't be heard. They could be the video isn't good at one end, or they don't have they're using wireless for Zoom, and it's all muffled and in and out. I've had upwards of 2-hour delays in a particular day of deposition. So you have to, you should talk with the opposing counsel about that and make a record every time. If you're taking a deposition, make a record. You ask the court reporter to state the time she got off, there was a problem, and the time they got back on, and state how long it was approximately. So at the end of the day, if you go back to that transcript, you can add up the total time. So that if you have to go back to the court and ask for more time for a particular witness or two, you'll have what you need to do that. So with that, I open it up for any questions.
And actually, you can probably, folks, while you're hearing us present, you could put your question in the chat, and then we could read those questions off and answer any questions that way. I think, Bob, probably one of the big takeaways from your presentation that everyone should be left with is, look, when you do these depositions remotely, you're giving up a lot of control. I think you're really giving up a lot of control because you're in your office and you have opposing counsel and the witness remotely. And so you don't know what's being passed back and forth. You're not in a conference room where you can size up the witness with your own eyes. Really, you see them on a screen. And I think so much is lost on a screen. And that sort of leads me into my topic, which dovetails nicely with Bob's, and that is, court proceedings and arbitrations. There's a lot of similarities between those proceedings and taking depositions, but there are some differences. So there are 3 different types of arbitration proceedings that I've been involved with since COVID erupted. One is the court annexed arbitration. So you have your typical personal injury case where you've been selected, and it's usually 2 parties involved with a single plaintiff. And many times you don't have the defendant even present during the proceedings. The other type is a labor arbitration. So there's a grievance arbitration that arises under a collective bargaining agreement. And you have union representatives, you have municipal representatives, and you have the arbitrator. And then the other type of proceeding is a commercial, complex, either construction, trust, whatever, where the parties agreed to go to arbitration. And listening to Bob, I think it's very, very important for the arbitrator, and I'm guilty of not having one, but now I learned from him, to have a protocol in place before the proceedings convene, so that everybody knows what the expectation is of the arbitrator of the entire proceeding, so that it runs smoothly. But inevitably, it does not run smoothly for a number of reasons. I think technology gets in the way. But here's what I would suggest for anybody who wants to continue with the virtual arbitration proceedings. Please, please get your exhibits together in advance and send, I like a hard copy in a binder from each party, as well as digitally, so that, if it's a manageable number of exhibits, produce them in a binder and then send them electronically. And I like them electronically because I like to control the screen. If I'm the arbitrator, I want to control the screen during the proceeding. So if someone's referring to Exhibit 25, I pull it up. I may have already highlighted it, scanned it. It's there. I usually don't show scanned or highlighted documents to witnesses, but you can obviously highlight as the witness is testifying. But I want to pull it up. Everybody has the document in front of them. There's no question about the document. A lot of the same problems I've encountered in the arbitration proceeding that occurs during the deposition, and that is, and it really depends. So sometimes the attorney for one of the parties is in a different location from the witness or their own litigant who they represent, and that was just a result of the COVID environment. And so you don't, again, you lose control. You don't know what documents or devices are being shared with each other, or whether or not there are multiple people in the same conference room. I had a construction arbitration where the attorney was there with the party representative and other witnesses, and you only have so many devices, and some of the parties were speaking to the witnesses while they were testifying, and they were prompting the witness during the course of the proceeding. And that just can't happen because it is very chaotic. And then you have your technical issues where you may lose Zoom, or someone's internet connection is not all that strong. So for me, it's that loss of control. It's the loss of the personal connection that I feel is most, it's a real disadvantage to conducting these proceedings. I did a trial in front of Judge Leach in Kent County during the pandemic. We did most of it in court, but because of certain conditions, we had to finish the trial up remotely. And we had books of exhibits for the judge, and some of us had them digitally. But the judge, and like judges and arbitrators, they like the hard copies in front of them. But I'll tell you what was very disconcerting, and it's happened to me, and I've done it in the arbitration proceeding, and it's not a good thing. A witness will be testifying, and the judge is set up with the screen, or the arbitrator is set up with the screen, and you've got your credenza behind you with the exhibit books, and you turn your back to the camera. And so both the attorney and the witness say, "Hey, judge, should we break? Mr. Arbitrator, should we break? You're not paying attention to my witness. You're not paying attention to the testimony." And at one time, the judge was bending down. You couldn't even see him. He was off the screen. And so the concern that I have was, has he lost interest in this case? Is he paying attention to this critical testimony or exhibit? So all the more reason to have an established protocol when you go in. I mentioned the concern with multiple individuals in the hearing room and the ability to transmit information. If you're going to do it virtually, I think you really have to be separated. Bob says, look, you need to be with your client when you're defending a deposition. I agree with that. And perhaps his instructions about, you know, sort of monitoring and taking a poll of what devices are in the room and having a pre-arbitration interview with everybody and go through the protocol so everybody's on the same page. Now, in arbitrations, as you know, some people like to use stenographers and some people don't. A lot of times, particularly I find in labor arbitrations, the litigants say, no, we'll rely on the arbitrator's notes. We'll rely on the arbitrator's notes. In most instances, they're representing public sector clients. They don't want to spend the money for the transcript or whatever the case may be. I find that the case also with some commercial arbitrations. People do not necessarily want to invest in a transcript where it's, you know, a 5 or 10 day proceeding. So what's the official record? Well, could it be Zoom? Could it be a recording on Zoom that you then share on a daily basis with the parties? I have no problem with that as long as I think you obtain the consent of all of the attorneys involved in the proceeding and the parties that they represent. It's cheaper, it's accurate, you can play it back. I had a case where I had to make pretty heavy findings of fact in a construction case. And I relied not only on my notes, but when there was a question in my notes and I wanted to review the testimony of a witness just to see, geez, did they really say that? Are my notes accurate? It was a double check. And I went back, and you have the ability to review the testimony, either when you're preparing your post-arbitration brief, or if you're the arbitrator, to prepare your decision. I agree that I mentioned some of the distractions. Bob also mentioned with the use of exhibits. I tend to control the screen. And if I want to put an exhibit up when someone's testifying, if I'm the arbitrator, I like to do that. I mentioned the arbitrator, try not to turn away from the camera. The parties have spent a lot of money coming to the table to have this dispute arbitrated. They want to know that you believe their case is important, and they think they've hired you because they think that you're, you know, impartial and fair and reasonable, and you'll render the right decisions. So show interest in the case, as difficult as it may be, seeing everybody on screen as opposed to being in a conference room or a courtroom. You know, keep your interest up and pay attention to the litigants. And then lastly, what I wanted to just bring up, what are some of the benefits and drawbacks about these virtual proceedings? And just giving this some thought, the temptation is that it may be more economical for the parties, right? Certainly depositions. If Bob needs to take a deposition of a witness in Boston, well, he just saved his client a lot of time, you know, traveling to Boston. If we're going to start at 1 o'clock, we're going to start at 1 o'clock, and it goes to 5 o'clock. That's it. It's not, you know, those 4 hours or 5 hours plus another 2 for travel or whatever, you know, getting into the building. And that's, I think, the biggest advantage. And maybe Judge Sullivan can address some of those, because I know that she intends to continue doing mediations virtually. I think the drawback, though, at least from an arbitrator's perspective, is that I need to see that person in front of me, not on a screen. I need to see that person so I can size up their reaction to questions from their own attorney or during cross-examination. I need to see the body language of that witness because I make findings of fact, and it's in large part based upon the reaction of the witness. Are they telling the truth? Are they hiding something? Are they not being forthright? And I think, at least my experience has been, you lose some of that when you assess someone's demeanor over a screen. So I'm really curious as to whether or not the labor arbitrations, the construction arbitrations, the commercial arbitrations will continue on the virtual path. I'd really love to poll the bar on that issue. I think the court annexed arbitration, those seem to be working fairly smoothly and they're very convenient. Most of those last an hour to 2 hours. And I think it's just much more convenient for the parties and the attorneys to do them from their office. So those are my thoughts on virtual arbitration. So why don't I turn it over to Magistrate Judge Sullivan to talk about mediations.
Okay. Hi, everybody. I see a ton of people in the list who have mediated with me, so they could probably give this presentation better than I can. I want to begin with an overview of what we're doing now and what near term becomes possible for the three choices for court-annexed mediation. I will be talking only about court-annexed mediation. Private mediation, of course, is a whole another topic. The three of us, that would be me, Judge Allman, and Barry Mitchell, have all been conducting mediations by various remote methods. In the near term, the Pastore building has not yet had its various spaces vetted for safety. Mediation requires in person, requires the mediator to have access to adjacent to each other, small, little, tight, typically airless, window-free, miserable conference rooms. And the parties sit in these conference rooms. It sometimes gets pretty ripe in there by the end of a mediation. In the new world that we're now living in, we're not going to be putting people into tiny little unsafe conference rooms until the safety has reached the point where we're confident that that's safe. So while the court itself is officially open as of June 1, we've been conducting proceedings with juries, well, grand jury for months, jury trials for months. Those are being conducted in spaces that have been checked. And the spaces available for mediation don't fall into that category. So looking out into the fall, I can't say when it would be realistic for me to do an in-person mediation because of those circumstances. It is conceivable if the parties were passionate about wanting to be together in person, that we could figure out some plan for overcoming the impediment. But in general, I would say, notwithstanding what's possible for other things, for purposes of court-annexed mediation, using the court mediators who in turn have to use conference rooms in the Pastore building, we're talking unknown future when that opens up. The mediation methods for Judge Almond and me are essentially the same. Barry Mitchell uses a very different set of protocols, as I understand it. And of course, I've never participated in one of his mediations. So I'm just going to sort of give a heads up and then for the rest of my discussion, I'll be talking about the way that Judge Allman and I approach mediation, and more specifically, how I approach mediation, because that's what I know about. Barry Mitchell uses a telephone service, the AT&T telephone services. I believe he sets up a dial-in, and parties dial in and then drop off and then dial back in. He also uses FaceTime, and you can FaceTime with a bunch of people, I think up to 32 at a single set. And he often uses both methods, both the telephone and the FaceTime, to conduct his mediations. Judge Allman and I, which is the rest of what I'm going to be talking about, use telephone and Zoom. And now I'm going to kind of drill down on what are the pieces of mediation, how are we doing them in a remote environment, and then focus in on what are some of the things that I think are going to facilitate a successful mediation, recognizing that unlike what everybody has talked about so far, mediation often succeeds if there's informality, if people are relaxed, and there's effective, real communication, which is very different from the crisp, accurate, unmessed up record that you want if you're in an arbitration or you're taking a deposition. So mediations before COVID and now and continuing into the future, in my world, always begin with a phone call with the attorneys for the parties following the matter being referred for mediation. That phone call is generally using the AT&T line. It is unrecorded. That phone call is a mediation communication. So the kind of candor that we can have in mediation, I expect from the parties. And the topic for that pre-mediation call is whether the parties really want mediation, whether the time is right, whether there's more work to do. Sometimes that call will lead to an agreement that the parties will exchange certain discovery and that we will postpone the actual mediation itself until after some work's been done. My approach as a mediator is never to give parties orders, that everything that happens under the umbrella of mediation is based on agreement. So if there's exchanges of information, it's done by agreement. The next thing that happens is that I will issue an order that sets up the mediation. It's short and quite simple, and Nora's going to flash it on the screen for a split moment because it's not all that important. Or if you could just scroll down a bit so that the first, we get rid of the notice of settlement and just scroll down so people can see that essentially what this is. So this is post phone call. We've already begun the mediation. We've had a phone call with the parties. The parties have agreed to the date that I'm going to fill into that blank. The notice stipulates that it's going to be by Zoom. The usual language about needing to have the appropriate people. We generally discuss who are the appropriate people during the phone call. And then the rest of the meat of this order, which begins, Nora, if you could scroll just a little bit more so we can see the, there you go, stop, are the statements. 5 days before the mediation, I want the statements. Those are not filed. The court has a URL that you email them to, and all of the statements and the documents do not ever need to leave digital format. So you don't need to provide me with a book of hard copies. Simply send them in digital format to that URL, and I will read everything that you provide. Under my protocol for mediation, the statements are exchanged among all parties, And any party that wants to say something to the mediator that nobody else sees may provide a confidential statement. Nor, if you could scroll down a little further, we've got the confidential statement referenced. Okay, take it down, unshare. That statement, the statements and the documents that are attached to the statements are something that in mindful of some of the things that Messrs. Duffy and Oliverio said about the document challenge and the problems with screen sharing comes into play in mediation. The documents that you attach to your statement should be the documents that you're going to want the mediator to look at and the other side to know you think are the important documents. Less is always more with mediation. This is not, again, you're not marking exhibits, so you don't need to give all of a document unless it's all important. But I echo the themes from the earlier speakers that during a proceeding where my ability to see and observe and assess demeanor is critical to success, which is what mediation is. Screen sharing is a problem and it gets in the way. And I urge you to take advantage of getting the documents digitally to the other side and to me 5 days before. That's what my order calls for. And then everybody is operating on a shared set of what are the important documents when resuming, and we don't need to share the screen. When I begin my Zoom session, I first of all require that everybody has their cameras on. I once had an insurance adjuster who thought she was special and she didn't have to turn on her camera, and the mediation failed. I learned from it. Cameras on is an absolute requirement. I begin with a plenary session so everybody can see who's there. Everybody can see everybody else. Particularly if we have some inexperienced litigants who are participating in the mediation, I give a little overview of how mediation works, what we're going to be doing, what's going to happen. I always highlight that the mediation is confidential so that we can't have social media postings about what's going on in the mediation while we're doing it or afterwards. After the plenary session, during the plenary session, each attorney may make an opening statement. Again, don't flash documents on the screen during that opening statement. And of course, because it's mediation, the goal of the opening statement is to not polarize at the same time that you want to set a tone for where you want to go with your position in mediation. I then set out breakout rooms and I shovel all the participants into private breakout rooms. Some parties like to be in breakout rooms with other parties if interests are aligned, very much as if they would have sat in the same conference room before. In the breakout rooms, you are in complete private. If for some reason you need to get to the attention of the mediator while you're sitting in your breakout room, there's an ask for help button on Zoom that you can hit, and you will get the attention either of my law clerk, who generally acts as the host for mediations, and then my law clerk will, if I'm in the breakout room with somebody else, she'll have the ability to go find me and send me to you so I can solve your problem. But the ask for help button on Zoom is the same as leaving your conference room and knocking on the door of chambers to say you've got an emergency. I go back and forth between the breakout rooms. Zoom allows that to be done in split seconds very, very easily. From my perspective, the principal downside is that I don't get any exercise because I just sit here and I move. As we roll forward, making progress, not making progress, if the mediation ends with an agreement, I use the Zoom recording function. During the mediation itself, the recording function is always off because the mediation is not on the record and it is strictly confidential. The only record of the discussion are the notes, my notes and the party's notes. But if there's an agreement, we make a recording. We do that at the very end. We close all the breakout rooms. That automatically brings all of the participants in the Zoom back into the main room. We turn on the recording. I call the case and I go through the terms and then ask each party if they agree and if there was any misstatements by me in the substance of the agreement. That recording is then, it actually, Mike Simoncelli gets it and is available. I've once had parties actually ask to have their recording so that they could get it transcribed. And then the mediation terminates. As with in person, I always begin at 2 o'clock with a standard normal bilateral case. If it's a multi-party case, we sometimes begin a little earlier. I go until we're done or until fatigue undermines our ability to proceed. If a case is more complex and can't be dealt with in a single Zoom session from 2 o'clock to 5 or 6 o'clock, then at the end of the first Zoom session, we can discuss how to proceed. And we can proceed either by another Zoom session or a telephone call. With telephone calls, again, I typically use the AT&T line so that if you want to do a phone call, we can have your client on the line, and I would have ex parte calls back and forth between the parties discussing how to roll the mediation forward. A couple of things in terms of mediation success. The key is effective communication. My own experience is that the more that I can empathize with a party and the party's position in the case, and with both parties equally, even though there's huge tensions between their positions, the more likely that I'm going to be able to achieve a mediated agreement of that case. So how do I get empathy in a remote environment? A couple of things. First of all, I have done mediations with people sitting around a conference room together, all wearing masks. Very ineffective. Can't see the faces. I have one box for the conference room, and each little person is a little dot. And when the dots are obliterated with masks, it's hopeless. I really can't get any sense of empathy going. Most effective is a situation if the attorney and client are together in the same conference room, but they each have their own device. So I've got a box for each person. I can see each face as clearly as possible. They can talk to each other while they're talking to each other. If they want me to see and hear, I can. So I can see the back and forth. And if any party wants to caucus privately, Zoom provides several very effective methods for doing that. You can ask for a private caucus. One method is that you simply mute the phone or mute the Zoom and step away from the camera. Mute the Zoom and turn the camera off, then turn everything back on and come back. Or I can leave your breakout room, and when you're ready for me to come back, you hit ask for help. If it's going to be a long private session, that's the preferred way. That is, I leave the breakout room, you're now in complete private, you have your discussion, you decide what you want to do, you hit ask for help, and I come right back. It takes me about 5 seconds from the time you hit the button until I'm back with you discussing what's going on. When the attorney and client are too far away from each other or in different locations, their ability to communicate effectively, I think, is not as good. That's why I think having them in the same room is the most effective thing. I have mediated with people in their cars. I would call that suboptimal. I have mediated with people on their phones, as opposed to on a device that's going to be more effective and have a larger screen. Phones are suboptimal. The lighting that individuals choose when they're participating by Zoom is very important. If the person is backlighted, I can't see any facial expressions as the mediator, and my ability to form that bond and become empathetic is going to be impaired. What I find is that once I've got a person in a nice big box, I can see the face, I can see the body language. It's, to me, just as effective as the in-person setting, minus the transactional cost of everybody traveling to get into the same room, and minus the transactional time of doing that. I mentioned the problem with screen sharing, and that I urge you not to do it. And then think about breaks. Sometimes if you know you're going to want a sequence of breaks, discuss that during the plenary session. There's nothing more frustrating than the mediator goes back into a breakout room and discovers that all the boxes are empty because everyone has wandered off to do something else. And we don't know where you are because you didn't say so. You can always go into the chat and say, the plaintiff is going to take a 10-minute break if I'm spending a long time with the defendant. But use the Zoom tools fully and completely, because it's awkward and difficult if the mediator returns and there's nobody there. The last thing I have rarely used in mediation, but the zoom.gov that we use allows for simultaneous translation. So if you've got a Spanish-speaking litigant, for example, Zoom means that I can hear the English translation simultaneous with your client speaking Spanish, and it works amazingly. We use it constantly and have a lot of experience with it. It's rarely come up in Zoom, but it certainly is something that could arise. So I think I'm almost out of time, so I'm going to be quiet.
Have a question. I do have a couple of questions for you, Your Honor. So the first would be, have you had the opportunity to assess the success of doing these mediations on Zoom via in person?
Scientifically, no.
No, I'm sorry. Well, what's your sense?
My sense is that it is just as effective as long as I can see the people, I get all the people into boxes that are, and they're close enough to the box and they're not masked, so that I can develop that empathy. And the individual party, so the human being who's going to be deciding to spend their money or not spend their money or get some money, that person is comfortable enough in the Zoom session to start talking to me comfortably. That's when the empathy arises that really leads to effective mediation.
So when it's safe to go back in the Fogarty and everything's opened up, are you going to prefer the Zoom
I don't know.
platform? You don't know.
I don't know. I really don't know.
I'd really like to get a sense from the bar as a whole as to what their preference would be on all these types of proceedings.
I think if it's perfectly safe and the attorneys all prefer it, then in person is great. If it's perfectly safe, but there's a party who's in, I mean, I did one where there was a litigant in Tel Aviv. We probably wouldn't have been able to do a mediation. I don't know what we would have done. He certainly could not have come in person. But he participated equally, other than that it was the middle of the night. He was equally as effective in a Zoom mediation as he would have been had he flown all the way from Tel Aviv. Insurance adjusters, in the old in-person days, I used to get them on the phone, and it was pretty darn ineffective.
Yeah.
Because you couldn't beat them up.
Right.
But now I can get that insurance adjuster. I get a box. I get somebody I can talk to. I've got the camera on, and I can really put the right kind of pressure on the insurance adjuster, the insurance adjuster is on the same level playing field with all the other participants.
And so I'd like to see if anybody participating this afternoon has any questions of any of the panel members or would like to share their own experience. Bob, any closing comments?
No, thank you guys for excellent job done. I did have one technology comment, which is, I'm not sure how Magistrate Judge Sullivan deals with this, but if you're in the same room on separate devices and you're accessing Zoom, you're going to get feedback. So you have to, I would recommend that you if you get a Zoom account, it's not that expensive, get a pro Zoom account, and then set up a meeting with your client in advance in the same room when you're prepping, and just do it and see what happens. Because you're going to have to mute a few things. You have to change a few settings on your computer and only be accessing the audio. So I just want to know that.
Yeah, no, that's an important point, because if it's just a good old fashioned, sort of low level Zoom account with maybe an iPad and a laptop, the feedback will send everybody right through the ceiling.
And my understanding of both the state court and federal, so Superior Court uses the WebEx platform, which has its own issues, and then Zoom and federal court. But my understanding is that most of the jurists prefer the court conferences and even motion practice to remain in the remote virtual format going forward. So a lot of this is going to be retained, and we're really going to have to learn to adapt to this new environment. And I think there's even talk about, even though the court's opening up, there was talk earlier about doing some jury trials virtually. I don't know how well that would work, but so Judge, you have any final comments before we close?
I think what's next is absolutely clouded in mystery, and we're going to stumble along probably for 5 more years, and then we'll look back and go, okay, now we know what was next, because what of all the things we've learned how to do, what should be kept and what should be discarded, what's better and what's not better, is we don't know yet, and we won't know until we start to go back and kind of figure out from the menu, which has markedly changed from what it was pre-COVID, what's the most effective way to justly and efficiently resolve disputes.
The one comment that I would make is a little different, and I think we can't underestimate the sort of the human toll of having all of this virtual proceeding, because I think it's really important for your own good mental health is to have that interaction with counsel, with litigants in person, or at a committee meeting or a bar association meeting. I think that's so important. It's very convenient and economical to be with the virtual format, but I think we have to look at other issues, much like what students and families have gone through in the last year in terms of the educational system. So those are my closing thoughts. Well, I want to thank everybody for joining us this afternoon, and we'll see you hopefully in person, and if not,